that should be available for an imbecile. We have to do better. The question is how, and how do we move forward in a concrete way, realising the difficulties, realising we don't have our own police force, realising we can't even set foot into a country without cooperation and assistance, where we make some difference and we start showing that this court is not, as I said during, Janet, your interview, is not some kind of paper tiger. It's not a vanity project. It can make a difference, and we need to prove the concept much more than we have. And I say that there's been, of course, very important achievements. It's a great achievement having a permanent court. It's a great amount of effort has been done. But I still think there are many constituencies, not just states, victims, who we can promise the world to, raise the expectations of, get wonderful support when preliminary examinations are announced. And then once they're taken to the heavens, they crash in the most painful manner, which is cruel and unusual punishment for people that have already, for groups that have already suffered more than any human being should have to bear in many, many situations. So how do we move forward? I mean, this is one of the key issues. Ultimately, the office, I think, has spread itself too thin. It's manifest in so many different ways. The workplace culture is also linked to that, in my view. Yes, there's management issues that we need to address. There's distance between the prosecutor and the deputy and the staff that the IER talked about. All of the reorganisation hopefully will address that. But across a range of issues, we're also asking staff to do too much. The gates cannot be constantly, and the example I've given, the Netherlands is the world's leader, maybe with Bangladesh, but the world's leader really in terms of irrigation and water control, water management. But the Dutch know more than anybody else that if you open the sluice gates, you'll flood. You won't irrigate. So we need to control so that we're not flooded, and more important than me, I mean, the really hard work are done by the colleagues, the staff, the men and women in the office, the people in the registry and elsewhere. But for my office, if we keep promising that we can do everything when we've got resources, we're lying. We're deceitful. We're raising expectations, and I'm not going to, whatever the consequences, I'm going to do my best, and I said it before I was elected, and I try my best to be true to my word. I'm not going to raise expectations, even if it means being candid and having the criticism. The simple truth is this: the budget that the Assembly of State Parties have, I hope by now, but I heard it was under the silence procedure proposed, is about 49.5 million for 2022. 49.5 million. In UNITAD, my last mandate, just for Iraq, just in relation to Daesh, putting the general budget together, which was, Tom, about 21, 22, and the trust fund, we had about 30 million a year. Now, I've got 11 investigations here, 16 preliminary examinations. Honestly, there's a degree of realism everybody needs to get. Because if you look at even at the IC2I, wonderful example, it achieved a lot over 25 years, and of course the residual mechanism is still there. But at its height, Thomas, you will know, all of you will know the statistic, at its height it consumed 1/6 of the entire budget of the United Nations. So when you compare what the demand is of the prosecutor and the incessant demands to everything, it would be very easy for me. Yes, I'm doing it. I am not going to have ghost teams. I'm not going to have phantom teams. I'm not going to, proceed and give an impression that there is activity when there's not, because I think that is not honourable. I don't think it's consistent with my integrity. I think it leaves a nightmare for one's successor, because then you come in and you see, in some cases, it's Old Mother Hubbard's cupboard, as the poem goes in English. And so this is something where we have to move forward with a degree of candour. And you have an important role, because whatever we do, there's going to be criticism. And as I said also, I am lucky enough, I'm thick-skinned. It goes with the job. But what we need to really understand is the key issue is the noise doesn't bother me. What bothers us is we cannot play with victims and survivors. I spoke to one NGO recently, and they were raising Afghanistan to me, and they were telling me to do X and telling me to do Y and so on and so forth. And I actually said a couple of things to them. Firstly, my view is in the same way states shouldn't be directing the prosecutor. I think that should apply to anybody. There's a position, a point when the spotlight is put on atrocities to raise the public consciousness, which is key. But once matters are sub judice, you've got to trust the institution. You can question, but it shouldn't be so direct as do this and do that, because nobody knows the strength of evidence or the issues in a case better than the men and women in the office of the prosecutor. I think that's important to bear in mind. But the other point, in terms of this, I said, look at Afghanistan. That was the issue they raised. Yes, I could do everything in Afghanistan, but you would cry blue murder if I do nothing in Myanmar or nothing in Philippines or nothing in X, Y, and Z country. So what do? The only thing one can do is go where the most serious crimes are and prioritise, as the independent expert report said. We need to prioritise situations. I'm in the process of looking at that. I don't have all the answers. I've conducted quite a few, I've had quite a few briefings. I've got a couple more to come. And we will, next year, I'll have greater clarity in terms of some of the more complete prioritisations, and then also willingness that within situations also we can't do everything. We have to prioritise, not based upon actor. There's sometimes maybe it was a complete misunderstanding, based upon the gravity of crime, where the worst crimes are committed, and then by whom, and then try and focus there and make a difference, because that's all one can do. And that's what any domestic prosecutor does, juggle resources in a way that can make an impact, with a degree of integrity, with a degree of sincerity, with an effort to make a difference. And then, of course, yes, we live in an imperfect world, but we have to also, there are different audiences that have different responsibilities. Our funding, our budget, our resources, and our cooperation are not entirely within our control. We can try to do better in terms of the communication, the point I started with. We can try to do better in terms of the quality control. But ultimately, the only way this office will succeed, the only way this court will thrive, the only way we will grant greater protection and we will inch closer to the promise of never again, is by building more partnerships. This is the only permanent international criminal court we've got. So we need to understand that as well. Let's try and support it. Not you, you must be independent and say whatever you like. But those that want to really have a better tomorrow, try and support it, and with a degree of candour, but realising it's a difficult challenge and it needs help. And that extends to obligations that go beyond staff members of the office. It goes beyond staff members of the court. It is something that should run like quicksilver amongst every sentient human being. And that's something I actually very strongly believe. So those are my quick remarks, unless there's any big issues you think I should address.
Thank you, Mr. Prosecutor. Thank you for that rich, open, and quite candid opening remarks. I think the idea was to give the President of the Foreign Press Association of the Netherlands just a few minutes to perhaps present the good work that you do before we open it up. And I'm conscious of the time as we're wrapping up. Of course, this is the first, hopefully, of a number of regular interactions with the prosecutor in the office. So we thought it would be great to have this opportunity of this first exchange and get to know one another. I know you're eager to ask direct questions, so let's not delay that. But before we do that, without further ado, I'll give the floor to...
No, well, let me, as it's an informal gathering, and if the microphone is muting me. So I should say, with your leave, so one of the areas I started with, I jumped over. So next year, hopefully, I will be recruiting a P4 and a P3 level in the professional category of staff PIOs. I hope they will have strategic communication experience in all its areas, because we have social media, we have strategic communications, which is, all its parameters and contours. So I think when we recruit those staff, I think that will be an essential partner for you, and I'm sure he or she or they will ensure very regular meetings, and I look forward, it doesn't need to be decided now, for you yourselves to start thinking what kind of engagement do you want. Is it weekly, is it monthly? Of course, that person's or that group's details can be shared, because I think it is important that there is quick accessibility, and then that strategic communication officer should be able to be a port of reference for you going forward. So that's one important area that I missed. There will be others, I'm sure, that will come out of the woodwork as we go forward. But sorry for interrupting.
Thank you. I don't really want to waste my time by introducing us too much, but it's really nice to hear you quote Winston Churchill, because he used to be a member of our association. So that's really nice. And you see here that we have specialist journalists, but we also have generalists who do everything on the Netherlands. So you will get different questions from us that could be really go into detail, and others that could be broader. So it's really nice to hear that you want to talk with us and more regularly. And it's really nice to hear that we can work out a plan to meet you regularly. And yes, I would really start by opening the floor so we can have more of you. And will this be on the record, by the way? Is that fine with you?
Yes, it's fine.
Okay. Stephanie, would you start, please?
There are a number of
if I may, Stephanie, of course, the prosecutor knows you very well, but if you can present yourself and your affiliation before. I will ask all colleagues to do the same.
There are a number of cases that are still in preliminary investigation that, under your predecessor, are awaiting certain decisions. There was, for example, Ukraine that she last year around this time said that she would request the judges to open an investigation, and then we were reviewing all the cases. Do we expect an update specifically in that case, or will you release a report on preliminary investigations? Will we see that, or do you have any updates specifically on Ukraine?
May I do one by one so I don't forget? Is that all right?
Mm-hmm.
No update on that particular case. I will, as I indicated, in the ASP between now and next year, be announcing decisions on various preliminary examinations. But, of course, these are important decisions and many factors have to be considered. In terms of the report, no, I've scrapped that. I think generally, and I've said it quite openly, I think even before the elections perhaps, in my view, the preliminary examination process has become, unwittingly perhaps, but a centre of gravity of the office, whereas the centre of the gravity of the office should be trials and investigations. It should be leaner, it should be quicker, and it's a filtering process. And so I want less, there should be more focus on the meat, on what actually proceeds to investigations and trial. So there's no report, and you'll see in this ASP, we have very important side events, including cooperation, including MLAs. Today I've just finished one on children, and we've got later on gender persecution. I think this is really, critically important, but no reports in the next period in relation to that case.
Please go ahead. I also invite our colleagues who are joining us virtually. They can also ask questions. If they want to ask questions, to put their hands up virtually. Yeah. Colleagues will take a note, and then we'll make sure that we give them the floor. Please go ahead, and then after.
Yes, Elspeth.
Please go ahead.
I have a question about al-Bashir. You have been there in Khartoum, you gave the press conference. What does this memorandum of understanding mean? And could it also mean that, for example, your staff is going to hold the trial there?
The memorandum of understanding is what it does. There had been, by my predecessor, an MOU had been agreed for Ali Kushaib, but it was limited to that one case that is for which trial is going to commence in April, God willing, of next year. But there had been no attempt to have an MOU for the other outstanding warrants. So this MOU relates to Omar al-Bashir, former president of the Republic of Sudan, Hussein, and Haroon. And it commits, Sudan agreed to cooperate with the office pursuant to the Security Council resolutions. Now, as I made clear in Sudan, we need cooperation. We know the past, but we want to have more effective results in the future in terms of proper investigations and therefore accountability. The forum, and I've said it very publicly, and it's, what I try to say is capable of being applied consistently across situations, is The Hague is a court of last resort. So there are a number of different options. What's important are credible, not cosmetic investigations, credible but not cosmetic trials. A trial that is shielding or is a sham conducted by a national authority or any other would not pass muster, and it would not give rise to complementarity. So these are discussions that we were having. They had agreed that we could have an office, a permanent office in Khartoum. In fact, I had a team that was there in Khartoum that were about to start that, and we moved very, very quickly to establish that office when the coup took place. So I think this is an area where further engagement is possible. I'm hoping the team can go back, notwithstanding the coup. The way I described it, I think, in the ASP, it was an unexpected hiatus, or it was a hiatus anyway. We will see now, in terms of the period going forward, how we can engage with Sudan. The simple reality is this, and I would apply this again across situations. Many different international organizations, the Security Council, of course, bilateral states, NGOs, they have their proper right to comment on different areas of human activity, including the political sphere. For me, I don't think I can be that indulgent. It's not my job to comment on the type of government. What I have to focus on is accountability. Is there meaningful accountability? And if there's meaningful accountability, whether it's a state party or non-state party, whatever the type of government, that's their business. There's others that have every right to speak, but this office must be seen to be not in the regime change business. It must be seen to be, as far as possible, everything's political, but as far as possible, coming with clean hands, applying the yardstick of the Rome Statute. And I think, as I've said openly, I want to rebalance in terms of the prioritization of the court, that the Security Council referral should not come last, they should come first in terms of what we try to focus on, because of the Security Council's unique role in international affairs, in the UN Charter, for maintaining international peace and security with responsibility under Chapter 6 for Pacific settlements. And so I want to focus more resources and try to see, can we move forward the situations in Sudan and in Libya in the period ahead. So I think we want to talk, and I hope a team can go back this year, but if not, early next year.
Please go ahead.
You spoke at your opening address and also at length of the ASP about attempting to move prosecutions to locations on site in the region and the country specific. But as you just mentioned, there are a lot of concerns about ensuring that the Rome Statute is properly applied in jurisdictions where courts traditionally may have not sort of adhered to those principles. Can you say something about how this institution plans to do that, and also with a lack of enforcement mechanism, ICC, as you said, there's no police force, how you're going to ensure that those kinds of prosecutions are being done, in adherence with the Rome Statute?
Yeah, it's a great question. I think one of the many reasons why I love the law is when we trust the law, it tends to show it is tremendously resilient and adaptive to the vagaries of human nature and to different circumstances. If we trust it, it can be applied and it can work. But very often, and I've said this quite openly, lawyers, and sometimes particularly common law lawyers, are lacking because of the principle of stare decisis, perhaps. Maybe because we try to do, using precedent, we use do in the future, or we do in the present what we did in the past. I think this is a new model that will show in due course it is the right way to fulfil the spirit of the Rome Statute. It is an ancillary consequence of complementarity, which seeks that states take on their own responsibility and do trials ideally at home. And if that's not possible, there should be accountability elsewhere. That can be at the seat of the court. But even the statute makes clear it does not have to be at the seat of the court, because Article 2 stipulates that the court can sit away from the seat. So that already is giving us some indication of what the drafters were thinking. But I also generally eschew binary options where possible, because very often when you look at it more closely, you see a variety of options. So if in the situation, if you contemplate a number of scenarios, and where the court sits is an issue for the judges, but one in which the office can make submissions, the ideal is the state does it itself. If not, we can try to assist under positive complementarity to a degree, realising we're not a development agency, but try to help with our technical expertise as we move forward with investigations. This is something we're doing with Venezuela. The third option is if the court can sit in country. If that is not possible because of witness security, the court can sit in the region. And fifth, of course, we have a seat here. But in addition to this, the binary choice between a state being unwilling or unable and then the case coming to The Hague, I think is one that can be further refined. For example, for the sake of argument, there is nothing stopping a regional organisation, like ECOWAS for the sake of argument, but any others, to come up with a position in which they may be willing, by way of a political decision, they create an agreement that if in a circumstance where a particular country is unwilling or unable, and before we enter, they can come to an agreement, say they will step up. And I think that would be perfectly acceptable. Hiss and Habri worked. So that can be done at the regional level, it can be done at the continental level under the Malibu Protocol. Of course, that has to come into force and it can be refined and it's not perfect. But the point is, I keep saying, and I need to do better at communicating, perfect, as Voltaire said, I think I said that in the ASP, is the enemy of good. It's about narrowing this chasm, which is of an impunity gap, and getting more accountability. And we should be very generous and, in terms of what the fora is. It doesn't matter, really. It doesn't matter what the fora is. In fact, the closer to home, the better. And we can think more imaginatively of that option, because then also it deals with a number of issues closer to the people. I think all things being equal is best. I think the Special Court for Sierra Leone had I think there's research on it in terms of the impact on the survivors. Look at the outreach programme. Perhaps it's one of the best in terms of how it was received by the local community. That perhaps was not completely divorced from the fact that the seat of the court was not away from Freetown during at least the AFRC, RUF and CDF cases. So we can learn from that, and I think that new dynamic has a lot of potential. Of course, it depends on resources, witness protection, logistics, all these other variables. But sometimes you can also test the waters and see, and have bespoke options for different situations in a way that allows the office to do better and spread its resources also more effectively when there's no accountability option at all.
They would have some sort of oversight from the ICC, presumably, or some form from the Rome Statute, right? You wouldn't want, for example, Sudan to be running its own sort of court under the guise of the Rome Statute, but not adhering to the principles of Rome.
Well, if you don't mind, the question is a bit conflated. The first part I would disagree with you. The second part I would agree with you. Any state, firstly, we can't have knee-jerk reactions to say there are good states and bad states. Even in Netherlands, even in England and Wales, there are miscarriages of justice. So, nobody's perfect. But the provision of the Rome Statute is there in black and white. If any process is not genuine, if it is for the purpose of shielding or is a sham, that is an issue in which jurisdiction would rest in the court in relation to the normal jurisdictional requirements that are detailed in the Rome Statute. But I would think we should, the first opportunity should be given to the national authorities. And that's actually not my own view. That's the view of the Rome Statute in black and white.
Thank you, Mr. Prosecutor. I'm conscious of the time. There are 6 questions still left with less than 10 minutes. 3 from the floor, now 4 I see, and 3 from colleagues who are joining us virtually. Thomas, please, if you don't mind, then we'll come to you, and then we'll give the opportunity to our colleagues who are remotely joining the discussions.
Thomas Jafus, Journalist for Justice. You already mentioned the budgetary constraints and quality control. When journalists talk to diplomats about the budget of the ICC, they often say, well, in my capital, the court is perceived as inefficient because there are the acquittals of certain high-level accused after a decade of procedure. So, speaking of quality control, have you identified ways to improve the functioning of your office to be sure that before you bring a case before the judges, you have good prospects of obtaining a conviction? Other explanations that are given for failure of state supervision findings, the spirits have changed since the 1990s, when there had been the Sudan and Afghanistan.
I'm sorry, could you put the microphone a little bit away from your mouth, because I'm not hearing very clearly.
Have you been able in your conversations with diplomats to identify other reasons why states are not forthcoming with the necessary funding, the principles of both things necessary? And has that allowed you to develop a strategy how to obtain better funding in the future?
The first thing is this. I don't think there's only one strategy in this line of work. There's bespoke strategies depending upon who one is dealing with, as long as they are part of an overall coherent, overarching strategy. There are different states. We saw it in the budget discussions. We've had some very strong support from a variety of states. Others have different issues. Some are suffering from genuine and well-noted economic crises back home, and others, there may be a variety of factors. But for that, your investigative journalistic skills will be well deployed by asking them, not me. In terms of acquittals, I think it's not quite accurate that it's the acquittals that give the criticism. The criticism is the work rate, the throughput of cases, the numbers of cases for convictions, for, look how many trials over 20 years. And when an acquittal is issued, and it happens, it should be welcomed. It shows an independent judiciary. But when there's such vituperative or strident criticism, it means that any independent, objective prosecutor wanting to do better should read it very closely. That's not the tea leaves. That is actually reading something from a judge that's been appointed that has a mandate. And I think this goes to quality control. Quality control takes many aspects, and I won't have time even in a whole day to go through that. One example I just mentioned now when I was dealing with the side event on children is we shouldn't be having, and I said it very clearly, I don't want any case, definitely not any situation, to proceed. I need a bit of time to do the recruitment. That's another issue by itself. But there shouldn't be any situation where we don't have people from the situation country. If you look at some of the cases that have come before the court that maybe have not ended as the office would not have anticipated or have wanted, I think, clearly we can do better in that regard. I want to have both national professional officers in terms of situations where we're moving forward. We want people from the country. And I think it's invaluable. It's an injection of ability. What I had deprecated when I was being Defence Counsel, and it wasn't pejorative. It really was, vivid, yes, but not pejorative. I said one cannot be a legal commando parachuting in with your Archbold International in your backpack and think, the jurisprudence from ICTY can come forward. In any case I've conducted, victims, defence, prosecution, you need people from the country. They know the people, they know the undercurrents, they know the connections. They also know, in terms of do no harm, they will know the cultural sensibilities of how to engage with different people, realising their intersectional, and multiple issues that leads to disadvantage that one has to understand if you're going to confront them. So that's one way of doing better, because suddenly we're working in partnership with people that know the country or know the region, not thinking that we know it all because we've been in Yugoslavia or Rwanda or Sierra Leone or Cambodia or even The Hague.
Yes, my name is Karim Khan. I'm foreign correspondent for Reuters, Germany, Austria, Switzerland, and Luxembourg. With the prosecutor, I have two questions. First one is, you just mentioned that you watch that the most serious crimes are done very carefully. So my first question is, do you also watch China? What is going on in China, especially in the Western province in Xinjiang, where the minority of the Uyghurs are discriminated and a lot of them are imprisoned? Secondly, do you watch what's going on in Hong Kong, where democracy and freedom of press is suppressed? Do you watch how China behaves towards Taiwan, threatening and speeding up the threat to Taiwan? And do you watch that regularly people in China disappear? So as recently the female tennis player who we do not know what is happening to her. Do you watch this? And do you watch how the president of China, Xi Jinping, is going to behave as a dictator? And my second question is, please be so kind and give us an update of the Israel and Palestinian case. Thank you very much.
Thank you for that. I like current affairs, so I try to watch the news. And I certainly don't turn the news off or censor or edit what I try to observe and try to learn from. But I think the mandate of this office is quite heavy, and its jurisdiction is quite well known. So in terms of non-state parties like China, of course one looks at them in terms of communications that may be received. We look at them, but we make decisions based upon the Rome Statute. We're not so self-indulgent, and we should not be self-indulgent to try to superimpose our own proclivities or own political preferences or our views of the world. That's when international justice is undermined, and states and all actors start wondering, why do we set up these courts if the law, is the size of equity is the size of the Lord Chancellor's foot? If we start, having it in the image of a prosecutor who's there for a particular period or for a judge, there is a constant, which is the rule of law and the statute, and we apply that in a proper and principled way. In terms of Israel and Palestine, yes, I think the situation is well known. There was extensive review by my predecessor. There was litigation before the court, and that's a matter that the court is looking at, that the office is reviewing along with the other priorities and issues, and it requires, of course, some considerable thought and assessment as we move forward.
David?
Sorry, if I may, just keep in order, if you allow us, because I think you're waiting for some time before the question came.
Sorry.
Also, I think there's a list of questions from our colleagues that are following remotely. Perhaps we can give the opportunity to one colleague to first ask the question from who's following the discussion virtually. Joshua Rosenberg, correct? Can we give him the floor, and then we'll give you the floor, and then we'll see if you have any time left. Quite honestly, we've actually we ran over time already.
I just wanted to, it's Joshua Rosenberg, I'm a freelance legal commentator covering mainly the UK. I tell you can hear it. Can I just pick up what I think you just said at the moment, where you said the office is reviewing the investigation in the situation in Palestine. I wanted to ask you a general question. You said you had 11 investigations, 16 preliminary examinations, and you needed realism. Am I right in thinking then that you would be reviewing all those investigations and preliminary examinations, including Israel-Palestine, and that you might decide at some point in the future to abandon some of those cases in order to concentrate on cases that you want to prioritize?
Firstly, Joshua, very humble of you. I think you need no introduction, but maybe that's me as somebody coming from the United Kingdom. I think if I answer your question directly in the way that maybe it was presented, it would give a wrong indication in terms of a headline. It is correct that, and I think it was to be expected, and indeed incumbent upon me, to seek to review all the cases, situations, preliminary examinations that are in the court's docket. But that doesn't mean that there's any predetermination. But of course, I will only go forward in cases that have a realistic prospect of conviction. I've already asked in terms of the cases that are before the court for the senior trial attorney to attest in writing to me their judgment that there's a realistic prospect of conviction, and that is something that I'm going to, and I made it very clear to the office, a standard that I want to be adopted even before any arrest warrant application is made or any request for a summons is issued, so that, generally speaking, we see the evidence doesn't get better. There's a whole variety of reasons why the evidence can be eroded or be challenged because of extraneous circumstances. That's the first. But, of course, there may also be situations where there is evidence, and then we have to prioritise. That's the second issue. I dealt with that in Afghanistan in the way that I could. So everything in any jurisdiction, and there's case law on it, in the criminal sphere, any investigator, any police officer, and certainly any lawyer should keep the evidence under continuous review. And I will try to ensure that there are processes to make sure that is the case. You don't just fire and forget. One makes sure that one constantly has one's finger on the pulse, and this change of organisation in terms of the 2 deputy prosecutors and the new systems I'm trying to put into place hopefully will increase the quality control to make sure we go forward on cases that have a solid legal and evidential foundation. So that's the best I can give on that question.
Thank you, Mr. Prosecutor. Can we take it back to the floor?
Okay, give 5 more minutes.
Dan Kemp from the AFP, Conservations Agency. I just wanted to ask about Afghanistan. Obviously, you touched on it before, but I was wondering if you had, before making this announcement, if you, wondered that you worried that you could be criticised for bowing to pressure from the US on this. Secondly, very quick one, just in case David doesn't get this. On a possible Venezuela transitional mechanism, is that something that the office would be happy with? Thanks.
Yeah, also a great question. We should do more of these, certainly. It's quite fun. I think for all of you would know, and for us, and for me, it's not my first rodeo, as the Americans would say, but I wouldn't bow to pressure. I'm a Pathan as well as, the son of a Yorkshire lass, and we're known for being quite direct and stubborn where necessary. But I was constantly alive, and in fact, to the fact that it would attract, virulent criticism. And if one looks at the filing that I put forward was under 18.2 of the Rome Statute, was clear it was simply requesting an authorization, and I could have kept quiet. And some may have cautioned me to also keep quiet and let sleeping dogs lie and move forward. But I think that's not what is expected of me. It is to be slapped squarely in the jaw if people want to do that, but I will not bow if that's the right thing to do. I don't have resources, and I am not making decisions based upon any timidity. I'm basing decisions based upon the worst evidence. And one thing I will not be embarrassed about, whatever critics say, is looking at that situation and the 80 terrible allegations of torture regarding that had been made, and comparing it with the beheadings, the targeting of women and children in the most beastly fashion, looking at the scale and the gravity. I am not apologetic that the more serious crimes and the continuing violations were Taliban and ISIS. And I think it would have been easy to keep the status quo and leave it parked under the deferral. I think the proper course was not to be oblivious and to monitor the situation and decide my responsibilities required me to seek to move forward with the investigation, but then to square with those individuals, including victims and survivor communities that may not be pleased, that may have had a lot vested in it, that may have wanted a different response to say, I cannot do it. I must use my resources effectively and intelligently, and I'm sorry, and also I'm not. I've done the best I can do, realising that we have 123 state parties, 2 Security Council referrals, and 1 declaration. This is not, and we've got a budget that is really not in proportion with the responsibilities, and I have the responsibility to make the tough calls to try to make a difference, realising that thus far, if you look at the existing model, given the burden of proof, maybe we need to have more resources and to do better if we're not to get some results that we've had in the past.
Thank you, Mr. Prosecutor. We already passed time, but the prosecutor has been gracious enough to give us already 5 minutes extra. We're already eating into that 5 minutes. I can take 1 or 2 more questions.
No, I think
2 more questions.
no, 3. 1, 2, 3.
Okay, great.
Oh, okay, 4. But then that's it.
But also, there's also colleagues waiting.
Okay, so I'll leave it to you.
Yeah, you don't mind, Karim. Okay, so what we'll do, let's have an agreement by consensus. We'll do 3 more, and then we'll call it a day. This is just the beginning. We'll have many more opportunities for engagement. Okay. So let me take it back to colleagues who are following us virtually. I understand Mr. Meyer is waiting to ask a question. If I can give you the floor, and then we'll come back to the last 2 questions from the floor. Thank you.
Thank you very much. Good afternoon. Another highly anticipated case, I want to ask a question about the Bangladesh investigation. I was wondering whether you can tell us how this investigation is progressing and how it fits in the new strategy, also seeing that Myanmar is not cooperating. How would you say this is still a priority, or would you maybe deprioritize this investigation? And also, is it maybe broadened to include more crimes and political issues?
Well, this is a case. Firstly, thank you, Bart, if you don't mind me using your first name for the question. This is one of those where I've had briefings. I'm still looking at it vis-à-vis all the other competing obligations. I'm hoping to go next year to Bangladesh and look at a variety of challenges and issues, but I don't think beyond that it's appropriate to comment. I think the subject matter jurisdiction is well known, and the office is looking at it, and we will move forward over the next period. I'm sorry for that rather general question, but I don't think it would be appropriate to go into more detail than that. Sorry.
And the second question about comment that you made on the first day. This is very related. A comment you made on the first day of the Assembly of State Parties. I will quote you, this audit is not in the regime change bank business. Will you elaborate a bit more on that?
Okay. As it's our first one, your very clever attempt to ask 2 questions will be overlooked. In terms of Venezuela, I apologise. So this is why I will allow the second, because I didn't answer the first. There are models out there, and like cases should be treated alike. We're dealing, by its very definition, in more cases than not, or at least in many cases, the crimes within the jurisdiction of the courts are heavy. They are either widespread or systematic, or they're extremely grave, and very often they're complex. And they can be dealt with in a variety of manners. We have civil law, we have common law, we have the Rome Statute system. And within those, we also have variables. In Venezuela, we have the Special Jurisdiction for Peace, we have the Justice and Peace Tribunal system, and we have the ordinary courts. So we have a variety. We have 3 jurisdictions in Colombia, I was talking about, sorry, in relation to Colombia. In terms of Venezuela, yes, there's processes. They've had 12 new laws. The High Commission of Human Rights has made comments, but there's challenges. And what I said very openly, that given the consistency I strive for, I have to make a decision based upon the Rome Statute, and that involved an assessment are the conditions met to open an investigation? And the answer was yes. But going to what I said earlier, there's not a binary choice. In the same space and in parallel with that, we can try to move forward and assist a state to step up. And if a state steps up, and this is what the IAR report said, I'm not making it up, it's also drawn, it's also my vision, my view is fortified by the IAR report, that if a state can engineer or construct the necessary architecture for fair and credible trials, or at least to ensure that there's no impunity and there's not a sham process, the Rome Statute equation makes it clear what the result should be. It should be the national authorities taking charge, but we can't run down the clock, and this is why proceeding both with independent investigations in partnership, wherever possible, with the state is the way to go. And in credit to Venezuela, I've been invited back, and they haven't done what some countries have done, which is leave the Rome Statute or tear up the statute, and instead they're engaging with the prosecutor. And this goes to, do we want Pyrrhic victories or do we want sustained dialogue? And the other point is, and I think it's very important, an investigation, if it's genuine, should not have a predetermined outcome in terms of the targets or even the charge. It should look at the truth. And this goes to your second point in terms of regime change. The reality is, as Richard Goldstone is a want of saying, politics is at the centre and the margins of international law. And if you don't understand the politics, you won't understand the law. We're dealing by way of subject matter jurisdiction in many cases, either to non-state actors or state actors, in a political context. And there may be a variety of reasons from, as to why people may also want change. And you also need to look at the evidence through that prism, not be naive, to look at the evidence and try to make sure the evidence we collect is solid, is not tainted or constructed for particular agendas. And this is why it's quite obvious, I think, that the office must come in without political baggage as to what type of government a state should put in place. It's not for us as international servants. I'm an international servant. I happen to be a prosecutor and a lawyer, but countries are countries. They have a right to choose their model of government. And this office cannot be seen to be a tool or of other agendas, because when we do that, we will breach an important trust, which is needed in any lawyer to come with clean hands and with objective criteria, looking for the truth in relation to our mandate, which is well known in the Rome Statute. And beyond that, that's for other people to comment on, not for a judicial institution, in my view.
Thank you, Mr. Prosecutor, for that clear answer. One last question. It goes to you. You're a lucky man. Go for it.
Which case?
Do you see any political or non-judicial obstacles which prevent you from moving forward? And where is it on your priority list?
Every case has challenges and difficulties, but I think, as you would expect, I'm not going to comment on a particular one. There's no, every case has its own challenges. Ultimately, the decisions will be taken by way of a basic criteria, which is the sufficiency of evidence, and of course, but really the sufficiency of evidence and the gravity of the case. Should it be dealt with here or elsewhere? And is there evidence to give rise to a realistic prospect of conviction? And this is the yardstick I'll use across all cases. It will be the yardstick in terms of a request for warrants that I'll issue in my term, or request for summonses I will issue in my term. It will be based upon that standard of evidence and that review at that early stage. What we've seen is the staged approach does not work. Cases do not generally get stronger for a variety of factors. The high water mark may well be before somebody is named, and you have to make a call then if the evidence is capable of proving the case beyond reasonable doubt, and then you can look at ways, hopefully with that base, of dealing with the exigencies of situations and the unforeseen or the unexpected eventualities. But you have to operate in that way, in my view, in the international level. And if you don't, I think the system will not work. So that's the best answer I can give. So thank you so much for your time. I look forward to many more engagements. I hope many of you, despite COVID-19 and PCR tests, can actually go home and see your loved ones and families. Otherwise, enjoy the Netherlands, and I look forward to seeing you again, God willing, next year. So thank you so much. Perhaps the final word to you.
Yes, thank you so much for having us. I hope this is the beginning of a beautiful friendship. And yeah, we really hope to dive deep once the first cases present themselves, and we really hope to continue our dialogue. Thank you very much.
Thank you so much. Thank you.
Thank you, everyone. Thank you so much.
God bless. Bye. Oops. Is this card for me?
Yes, it's actually Rita's card.
Oh, good.
You know, if it wasn't for COVID, you would take a group hug picture. Really, no, honestly. But it's not in the cards, unfortunately.
Well, group picture, I think hug. I will. At least group picture we could do. Thanks so much.
Thank you so much.
Thank you so much. And we'll be in contact, I'm sure. Thank you.
Yeah. Cheers. Take care. It was great.
Hey, Sam, let me give you a
We just got them actually for the immediate office. Sorry, I have to do it. My apologies. Excellent. Thank you very much. Well, of course, we have our contacts. We'll be continuing in contact.
Yes, you have.
And as I mentioned, he mentioned already also that we will be recruiting additional staff. So that will free up us a bit more to be able to engage more regularly as well. So we look forward to it. I think it's mutually beneficial.
Yes, and I think people got what they wanted. So
That's good. That's good. He was quite generous actually. He went 20 minutes. In
Yeah,
fact, he's late for a bilateral. That's why he ran. He's late for a meeting.
Thank you very much for your hospitality.
It was a pleasure. Thank you. No, thank you. The pleasure's all mine, and I'm going to give you my card as well.
Okay. I do appreciate it.
Here we go.
Thank you.
My pleasure. You have my contacts, but just it was really a pleasure.
yes, great.
Hi.
Thank you very much for having me at the association.
I know. Do you want to read?
The prosecutor.
Sorry?
Yeah, no, of course it's not going to happen this year, but at least you have my contact.
Yeah, I know.